This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
This chapter deals with contract law. It is based on the principles of English contract law, but many countries have roughly adopted those principles. English contract law is also law which is largely based on case law. And you'll see in the notes there are a considerable number of summaries of law cases. It has to be emphasized that you don't need to learn these, you don't need to learn the names of the people involved in the cases. The cases are there because they illustrate the legal points and really bring it to life a little bit. So what do we need for there to be a valid contract? First of all, you need agreement. You need agreement, and that comprises offer and acceptance. The offer is the suggestion made by the offeror, and acceptance is made by the offeree, the person to whom the offer is addressed. You need something called consideration, which is broadly the promise of value passing each way. There has to be an intention to create legal relations, and this isn't just some trivial, social, informal type of agreement. And finally, you need capacity. For example, you need to be old enough, or you need to be of sound mind. Note that most contracts do not have to be in writing. A few special ones do, but most do not. And if you're ever confronted with somebody saying, well, do you have that in writing? And they say it has to be in writing to be a valid contract. Generally, it doesn't. However, if you don't have anything in writing and the other person chooses to tell lies, then of course it could be difficult for you to prove that a contract actually existed. But that's not to say that there isn't a valid contract. So let's see first of all about offers. And offers can be express. So, for example, I say I offer to sell you my car for $12,000. So that is an express offer. An offer can be implied usually by action of some sort. So if you're in a supermarket and you put some goods in your basket and you take them to the checkout and they're put through the checkout, you haven't said anything to the checkout operator at all, but obviously by your actions you have essentially implied that I want to buy these goods, and by the supermarket checkout person ringing these goods up, that is the acceptance. They can either be made to specific individuals, and if that is the case, then only those specific individuals can accept. So if I say I offer to you to sell you my car for $12,000, and that is only you can take that up. None of the other people listening can do that. Or it can be an offer made to the world, such as offering a reward to find a lost item. So let's have just draw your attention to a couple of the cases. And the first one is Carlyle versus the Carbolic Smoke Ball Company. And the Carbolic Smoke Ball Company was a company which marketed these devices and said if you inhale these regularly, then you will be immune from catching colds and flu. And this was their advert really in a newspaper. And Miss Carlyle went out and bought one of these, or a packet of these smoke balls, and spent a considerable amount of time sitting over a bowl of hot water with a smoke ball in it, inhaling these noxious fumes. But unfortunately she did catch flu. And she wanted to effectively get her money back or sue the company because they had really breached the terms of their contract. They had sold something which didn't do what they claimed it would do. And the company tried to say, this wasn't an offer to you, Miss Carlyle, this was an offer to the world. But the law held you can make offers to the world, and by Miss Carlyle buying the smoke ball and using it as directed, should accept that order, and compensation was payable. Note an important difference between an offer and an invitation to treat. If you see something in a shop window, which says, let's say it's a very expensive camera, and instead of putting a price, let's say, of $1,000 on it, they have mistyped it and they put a price of $100 on it. And you go to the supermarket manager, the camera shop manager, and you say, I accept your offer to sell this camera for $100. No, that display of the item in the shop window is not an offer. That is an invitation to treat. In other words, an offer to you, or an invitation to you to make an offer to them. Similarly, when you see goods in the supermarket shelf, that is not an offer to you to sell those goods to you. What you do is you put them in your basket. Then when you go to the checkout, you are offering to sell them, and by ringing them up on the checkout, that they are accepting that offer. So a good example of that is the second case you have there, Partridge versus Crittenden. This is where Mr. Partridge advertised certain birds for sale in the newspaper, and it was illegal to sell the birds, to offer to sell the birds. And Mr. Partridge was taken to court, and it was claimed that he had made an offer to sell the birds. And it was held by the court that no, he hadn't. He had advertised birds for sale, but if someone had responded to that, then they were making the offer to buy the birds, and only then, if he accepted the birds, would the sale have actually taken place. So an invitation to treat is not an offer. How can offers be terminated? Well, acceptance. So it's all kind of over and done with. If you say, yes, I'll buy your car for $12,000. Rejection. And rejection can come in a number of different ways. Rejection can be, no, I won't buy your car for $12,000. Or rejection is essentially, no, I'll buy your car for $11,000. That ends the first offer. Essentially, you are making another offer to that seller, and that seller can accept or reject that. Or if you were to say something like, okay, I will buy the car for $12,000, provided you put 2 new tires on it. That sort of negotiation, any sort of quibbling about the offer, is rejection of it. If it lapses, so if I say to you, I will offer to sell you my car, and I must hear in 5 days. If I don't hear in 5 days, then the offer is over. Then after 5 days, if no acceptance has been received, the offer lapses. Death of the offerer, where the contract is going to be one for personal services. So if I say to you, I will rewire your house for electricity, and I will do this for $5,000, and then a day later I die, you can't then come to my widow or my descendants and say, I accept his offer. Obviously, I'm beyond being able to do that. Notice for personal services, if it was for the sale of a car, then that could still be potentially accepted. Failure of a condition that attached to the offer. So I could say, I will offer to buy your car provided it passes a safety test. Okay, so that's my offer. Okay, so somebody has advertised a car. That's not an offer. That is an invitation to treat. I then make the offer. And the offer is, I will buy your car for $12,000, provided it passes a safety test. If it doesn't pass the safety test, then the offer lapses, and the person can't then accept it and force me to buy the car, and so on. Acceptance. Well, as we've said, acceptance must be unconditional. In other words, there can be no quibbling on it. There can be no saying, yes, I'll buy your car for 12,000 if you put 2 new tyres on it. That is not unconditional acceptance. Acceptance can be oral. In other words, you say to someone, I'll accept your offer. It could be in writing, very obviously. It could be by action. Like in the supermarket, I put goods in my basket that is taken to the checkout, and the checkout person rings them up. That is accepting my offer to buy the goods, but it can't be by silence. So it's impossible for a company to say to somebody, I offer you a subscription in this magazine. Here's the first one free, and if we hear nothing within a month, we will assume that you have taken up a subscription for another 12 editions. And you don't reply to that. In other words, you're simply silent. That does not constitute acceptance of an offer. The offerer cannot bully you into accepting an offer by assuming your silence is acceptance. Now, there can be some timing differences in offer and acceptance, particularly when these are handled by the post, the normal postal services. And the postal rules are, an offer occurs, an offer is there, if you like, when the letter containing the offer is received by the offeree. Now, of course, that makes sense. We can't be sitting there frightened that there may be offers speeding towards us that we've no knowledge about whatsoever. So only when it's opened by the offeree does the offer exist. Revocation of an offer is where you want to withdraw the offer, occurs when received by the offeree. So you can't be planning, if you like, to buy an item, and the other person has kind of posted a letter saying, oh, I made a mistake, I'm not going to offer it to you. So every time the offeree is sending out something, either the original offer or a revocation, then it is only active, only occurs really, when those documents are received by the offeree. If in the meantime I had accepted somebody's offer and I hadn't received or heard about their revocation, then there is a valid contract. Acceptance occurs when the acceptance letter is posted. So I get an offer, and as soon as I post the letter, then there is acceptance. The notes go into looking at what happens in more modern types of communication. Obviously on the telephone it's just as good as face-to-face. It's instant offer, instant acceptance. If it's email, well, it tends to be email when the email maybe gets to your server during working hours. But you couldn't send something at like 6 p.m. on Friday, knowing that somebody's office is going to be closed for 2 days and they're only going to go to the office on Monday, and say, right, that email was sent on Friday, I got the servers in your office on, let's say, the Saturday morning. That's when you received the offer. So have a look at these slightly updated rules for potentially emails, faxes, and so on. Consideration. Consideration really means that to make the contract legally valid, there has to be the passing of value of some sort in both directions, or the promise of the passing of value. Now, value could be a service. Value doesn't have to be goods or money. Value could be a service. And the rules of consideration are as follows. Consideration must be current or future, not in the past. So we have in the notes here, we have an example of, there we are, McCardle. So what had happened was a man died and one of his children moved into the old house where the father had lived, and the house needed a lot of renovation, and the son spent a lot of money in renovating the house. After that, the man's other brothers and sisters entered into an agreement where they promised that when the house was sold, that they would reimburse that brother for the repair costs. And that wasn't valid because the repair costs were incurred. That side of the bargain, if you like, was incurred way before any contract was entered into. That's what's known as past consideration. So the consideration either has to occur at the time the contract is negotiated, or it's promised to happen in the future. It must move between the parties of the contract. And here we have an example of a case, Tweddle and Atkinson, where two fathers had agreed to pay amounts to a couple when they were married, and one of the fathers died before the amounts were paid. And a law case came into existence. The two fathers had promised this to each other, that they would set up the couple, if you like, for their married life. One of the fathers died before the amount was paid, and one of the married couples took legal action against the father's estate to try to force it to pay the promised amount of money. And that didn't work because the fathers had promised each other. That was the exchange of value, or the promise of exchange in value. The promise had not been from the father, say, to the husband. And so the consideration wasn't between the two parties involved. It must be sufficient, but it need not be adequate. So sufficient means there has to be value of some sort, but it doesn't have to be adequate. In other words, the value doesn't have to at all represent, if you like, the true value. There just has to be some value, sufficient value. And the case there is the one of Nestle, Chappell & Co. versus Nestle, where there was a promotion being run. And what you had to do was basically send in 3 chocolate bar wrappers. And if you sent in the 3 chocolate bar wrappers, then you got some sort of reward from the promoter. And the promoter began to say, well, these chocolate bar wrappers, they're going to be thrown away. They're essentially waste paper now. But it was held that this, although it's essentially negligible in many ways in worth, nevertheless it is sufficient consideration. Someone had gone out, bought the chocolate bars, bothered to put the wrappers in an envelope and send them off, and even though the value of the paper they were sending is kind of zero, it was scrap paper, they were thrown away, it didn't have to be adequate, it was something. It has to be more than carrying out a legal duty. So you cannot form consideration by agreeing to maybe appear as a witness if there was a legal duty to appear as a witness anyway. That is not something extra, if you like. The contract demands in a way something extra both ways. And finally, the consideration cannot be illegal. So you cannot enter into any sort of contract where you say, I will pay you $50,000 if you kill that person. There may be value going each way, but the value going one way, the murder of a person, is generally regarded as being illegal, and that will not form a valid contract. There are a few contracts called specialty contracts where consideration is not needed. In UK law, there are elements like charitable donations can be made under what's called deed of covenant. Now, quite obviously, if you are promising to pay money to a charity, you're not really getting anything back from the charity. But if the promise is made under what's called a deed, which requires certain very simple, really kind of legal forms being signed, then that can be binding. But for most contracts, you need consideration. There has to be an intention to create legal relations. Informal social arrangements will not normally form a legal contract. So we have in the UK, you probably know the concept, something which is called maybe a potluck supper or a potluck dinner. And the kind of arrangement there is you've got you and 3 friends, and one of your friends says, you want to arrange a meal, but instead of one person having to do all the cooking, one friend says, well, I'll bring the starter or the soup or something. Another one says, well, I'll bring the main course. A third one says, I'll bring the salad and the vegetables. The fourth one says, well, I'll bring the dessert. And they come up, and the one who said they're going to bring a dessert doesn't bring it. Can you take legal action against this person who decides to skimp on their social obligations? And the answer is no, but because the law doesn't want to involve itself, irritating though it may be, the law is not going to involve itself in these informal social arrangements. Another time when there may not be intentions to form legal relations is if you put a subject to clause in a contract. So you could say, I will buy the house subject to a satisfactory surveyor's report, or like selling the car, I will buy the car subject to it getting proper safety certificate. Anything which is a subject to contract clause in it means you are giving notice, really. This I'm not forming the contract yet. Okay, we're kind of in the preliminary stages of negotiation, subject to contract. When we're both happy with the terms of the contract, then we can say, right, this is the contract, and you go from non-contractual duties into contractual duties at some point. And of course, this is really essential, otherwise negotiation on contractual terms and values and amounts and so on is going to be very dangerous. And finally, capacity. You have to have legal capacity to form a contract. In the UK, the age of majority, as it's called, comes at 18. And for many contracts, people under the age of 18 cannot enter into a legally enforceable contract. The exception is if it's a contract of necessity. So if you were, left home, university, 17 years old, living on your own, you go into a supermarket and you buy some groceries or something of that sort, and they're rung up on the till, and they ask you for the money, you can't say, you can't enforce that contract, because buying food is a necessity. The other main exception is a lack of mental capacity. So if someone is mentally ill or has periods of lucidity and periods of confusion, if they make a contract during a period of confusion, then they don't have legal capacity to do that. It's also being held that you cannot enter into a contract if you're under the influence, substantial influence, of alcohol or drugs, because you would not then have the legal capacity to know what you were doing. It should be said, under capacity, I'll say here, that companies have the capacity to enter into contracts. Companies are known as legal persons or persons at law, and they can enter into a contract. This is in effect caused by the directors, and provided the directors are acting within their powers, this will bind the company to a contract. If the directors are acting outside their powers, then the other party can normally enforce the contract, assuming they didn't know anything about the limitation on the directors' powers. Assuming they were entering into the contract with the company in good faith, they can enforce the contract, though the shareholders might be able to pursue this errant director for some form of compensation. So companies are perfectly able to enter contracts offers, acceptance be held to consequences of contracts. And this is, as I say, normally done through directors or other people within the organization, managers, purchasing managers, for example, to whom the directors may have devolved the powers to do that. Terms, conditions, and warranties. Well, a term is really any clause in a contract. And terms divide into conditions and warranties. And what you need to know is really the difference between these. A condition is fundamental, is vital. If a condition is not met, then the party affected can repudiate. In other words, they can refuse the contract. So conditions are vital. A warranty is slightly less serious. It is a term in a contract, but it is less fundamental. It is not, in a way, fatal to the contract. And what the injured party can do there is to get damages. So under conditions which are terribly fundamental, absolutely vital to the working of the contract, you can say this contract has been so undermined, I don't want anything to do with it. You can repudiate it. A warranty is less fundamental, a bit more of a detail, could be an important detail, but nevertheless the essence of the contract is still in existence, but you can claim damages. Two quite interesting cases are given there about some opera singers. We had Poussard and Spears, and we have Bettini and Bai. Both were opera singers. It's curious that they're both cases in the opera. And one was that the singer was engaged and because of illness couldn't attend the opening night or the opening nights. And here it was held that the opening night is so important, this is where the critics go, this is where you get your good publicity and so on, that the singer's failure to attend the opening nights was so fundamental to the contract, was a condition that the singer attended on the opening night, and that condition wasn't met, then the contract could be repudiated and this person could be replaced in subsequent performances. The other case, it was that the singer couldn't attend some rehearsals. It was a term of the contract that the singer had to attend rehearsals, and illness prevented attendance of all rehearsals. But the singer was well enough to begin to sing on the live performances, the real performances. And that was regarded as a warranty, that not going to several rehearsals was not so fatal to the contract, and the contract could still be enforced. You'll see in the notes that conditions can be implied, they don't have to be terms written into the contract, by custom, by fact, and by law. So if it is the custom, for example, in maybe selling a house, that you leave light fittings in place, but the contract says nothing about it, then if you didn't leave the light fittings in place and you left the new owners kind of in darkness, then they could pursue you for damages. It's unlikely that that's going to be a condition. It's going to be a warranty. So really, conditions and warranties can be applied by custom, or they could be applied by fact or law. So fact, here we have an example of the boat that was moored, the moorcock. If you are offering a place to moor a boat, then it would seem to be reasonable that when the tide went out, that sharp rocks would not go into the hull of the boat and cause it to sink. So that was implied by fact, based on the assumed intentions of the party. other parties involved. And similarly, they can be implied by law. There are certain contracts, maybe on renting premises and so on, where there is quite a lot of statute law which kind of oversees the contract law which may be in existence there, or consumer law. There are statutes around which says if I sell something to someone, it mustn't damage them, it must be fit for purpose and so on. And even though the contract itself doesn't say anything that these goods will work, if they don't work, then the law can intervene and say it was a condition or a warranty of the contract that the goods are fit for purpose. Finally, we have misrepresentation. Misrepresentation is a false statement of fact or law which induces one party to enter into a contract. And notice that we have the three requirements in here. The statement has to be false, that's the first thing. It has to be related to fact or law, not just opinion. Or not just guesswork. And it has to be a statement which causes or induces or pushes, if you like, one party to enter into a contract. So false, true is pretty straightforward. What about relating to fact or law? And the example we have here is Bissett and Wilkinson, where someone was buying some land to graze sheep on, and asked the seller, how many sheep do you think this will support? And the seller said, I think it will manage to support 2,000 sheep. And the seller had no real experience in sheep farming or no real idea of how many sheep the land would actually manage to feed over the year. It was this person's opinion. It was a guess, an estimate in many ways. I think it might support 2,000 sheep. And that was not a statement of fact, that was a statement of opinion. If this person selling the land had previously grazed only 1,000 sheep on it, and knew the land would only support 1,000 sheep, and then said it will support 2,000 sheep, then you are making a statement about fact, not opinion. And that would be then ranking as misrepresentation. It has to induce one party to enter the contract. So you might say this land will support 2,000 sheep, knowing it's wrong, but the buyer had no intention of putting sheep on it. The buyer was going to grow cereal on it. So even though you'd made a false statement of fact, and knowingly had made a false statement of fact, because the buyer couldn't care less about the number of sheep that would be grazed on the land because they were going to buy cereal, that can't possibly have had any bearing on accepting it. Misrepresentation can be innocent, it can be negligent, or it can be fraudulent. So misrepresentation, we know, can be innocent, negligent, or fraudulent. What are the remedies available for this? What can the person who has been hurt by this misrepresentation do? And first of all, innocent misrepresentation. So I sell someone a car, and I tell them part of the, let's say maybe a condition of this, is that the car has got a 12-month safety certificate in operation. But in fact, I misread dates or something, and it only had a 12-day safety certificate in operation. And the buyer pays me the money, about to get into the car to drive it away, and has a look at a safety certificate and sees it's only 12 days rather than 12 months. Now there, what's called rescission is possible. Reversal of a contract. It means trying to put the two parties back into their original positions as though the contract had never occurred. And it's possible there because the car hasn't changed, if you like, and I can get my money back. However, what would happen if the deal went through, the person got in the car and drove it around for 8 months, putting, let's say, 10,000 kilometers on the car, and then they look at the safety certificate and say, my goodness, it was supposed to be 12 months, it's only 12 days, and it's expired. Now there, rescission isn't really possible because the person who sold the car doesn't want a car back 8 months older and with an extra 10,000 kilometers on it. It's simply not possible to reverse people back to the position they were in. Things have changed. And the remedy there is going to be damages. Damages is a monetary amount paid to compensate. A negligent misrepresentation is a statement made without reasonable grounds for belief in its truth. So let's say the person asked me how long does the safety certificate last for, and I really can't be bothered finding out. I don't really care about it really. I just say, it's 12 months, kind of off the top of my head there. That's no reasonable grounds I would have there for belief in its truth. And there, the damages, this is getting more careless really. Here the damages are, or the compensation, if you like, is damages and rescission. Okay. Note the quite, I always think, quite difficult spelling of the word rescission. And finally, you have fraudulent misrepresentation. This is where a statement is made knowing it to be false, or really without any belief in its truth whatsoever, very, very recklessly and carelessly as to whether it's true or false, made really with the intention of making this false statement to induce the person into going through the contract. This is the most serious type of misrepresentation. And again, its damages and rescission are possible. And the court may well increase the damages there to add in a punitive element, an element of punishment to the person who made the deliberate fraudulent misrepresentation.